Dear students, I welcome you on behalf of Thakur Vidya Mandir High School and Junior College for the remote teaching learning process, where our motto is let learning be a joy and teaching a pleasure. Let us move towards part 2 of chapter number 4, that is issue of debentures, which is the concluding part of this chapter, wherein today we are going to understand provisions for issue of debentures as per SEBI regulations, procedure for issue of debentures, debenture trustees and debenture trust deed. In our previous video, we have already understood provisions for issue of debentures as given under the Companies Act 2013 and Companies Share Capital and Debentures Rules 2014. Now today, let us move towards the regulations which are laid down by SEBI for issue of debentures. Let us move towards question number 3 of this chapter, which is state and explain the requirements as per SEBI for issue of debentures. Before understanding the provisions laid down by SEBI, let us understand as to what SEBI is. SEBI is a statutory regulatory body which is entrusted with the responsibility to regulate Indian capital markets. It monitors and regulates the securities market and protects the interest of investors by enforcing certain rules and regulations. SEBI has laid down various regulations to be fulfilled by companies. As such, a company issuing debentures needs to follow Regulation 12 of SEBI, that is Issue and Listing of Debt Securities Regulation 2008. Regulation 12 speaks about minimum subscription amount to be raised by the company. It states that minimum subscription amount for public issue of debentures must be at least 75% of base issue size. Further, if this amount of minimum subscription is not received, then the entire money received must be refunded within a period of 12 days from the date of closure of issue. Let us move towards the second regulation of SEBI, which speaks about retention of oversubscription money. Sometimes there may be oversubscription, that is, the number of applications received is more than the number of debentures offered. In such a case, SEBI permits companies to retain, that is, keep the oversubscription money up to 100% of base issue size or any lower limit below it. However, it should be specified in the prospectus. The next regulation is relating to underwriting of debentures. As discussed in the first point of this answer, it is compulsory for a company to raise minimum subscription amount even in case of issue of debentures. As such, to meet this requirement, the company may enter into an underwriting agreement with underwriters for public issue of debentures. This underwriters help the company to raise the amount of minimum subscription. However, the prospectus must mention about the appointment of underwriters. The fourth regulation is related to credit rating. Credit rating is a measurement of a business organization's ability to repay a financial obligation based on its income and past repayment history. SEBI Regulation 2018 states that a company issuing debentures must get credit rating from one or more credit rating agencies like CRISIL, CARE, etc. Now, we need to know as to who are credit rating agencies. A credit rating agency evaluates and assesses, that is, it checks a company's credit worthiness. In other words, it finds out the company's ability to repay its debt and on that basis rates the company. Lastly, the ratings obtained by the company from these agencies must be specified in the prospectus. Let us now move towards question number 4, that is, explain briefly the procedure for issue of debentures. A joint stock company needs to follow certain steps which is called as procedure for issue of debentures. The first step involved is passing of resolution at board meeting. The board needs to pass resolution on the following matters. Firstly, resolution needs to be passed relating to the amount which the company intends to raise by issue of debentures. Then, types of debentures will be issued. For example, it may issue secured debentures, unsecured debentures, convertible debentures, non-convertible debentures, etc. And a resolution is also required to be passed as to the terms and conditions for issue of debentures. Secondly, resolution needs to be passed for approval of prospectus, which is also called as offer letter or letter of offer. Next is approval for appointment of debenture trustees and to get their written consent. Appointment of debenture trustees is important as they protect and safeguard the interest of the debenture holders. Further, a resolution needs to be passed for creating a charge on the assets of the company and thereby providing security to the debenture holders. Lastly, the board must be given authority to open a separate bank account for receiving money from applicants. So this is the first step involved in procedure relating to issue of debentures. Let us move towards the second step, that is holding of extraordinary general meeting. Suppose if a company wants to increase the borrowing powers of board, in that case it is compulsory for every company to conduct an extraordinary general meeting. In this meeting, the shareholders give their approval, that is permission, by passing a special resolution and thus increase the borrowing powers of board of directors. The third step is relating to filing with Registrar of Companies. Nextly, a copy of special resolution which was passed by the shareholders in the extraordinary general meeting must be submitted along with a copy of prospectus to the Registrar of Companies within a period of 30 days from the board meeting. The fourth one is obtain credit rating. The company must get its debentures rated by one or more credit rating agencies like CRISIL, CARE, etc. and the rating so obtained from these agencies must be mentioned in the prospectus. The fifth step is entering into an underwriting agreement. Further, the company needs to enter into an underwriting agreement with the underwriters for issue of debentures. As discussed earlier, these underwriters help the company to raise the minimum subscription amount, which is a statutory requirement as per the SEBI. The sixth step is issue of prospectus. After completing all the preliminary basic steps relating to issue of debentures, the company now actually issues prospectus, thereby inviting the general public to subscribe, that is, to buy its debentures. The seventh step is opening of a separate bank account. Once the prospectus reaches the general public, all those investors who are interested in buying debentures will start submitting the money to company along with the application form. For this, the company needs to open a separate bank account with a scheduled bank so that it can receive the money from applicants through these bankers. The eighth step is receiving of application money. It involves receiving application money. The company then starts receiving application form along with the necessary amount from the investors through the company's bankers. However, this amount must be received within the period as mentioned in the prospectus. The ninth step is holding of board meeting. Once the issue of debenture closes, another board meeting is held as the directors now need to take decision relating to the approval and allotment of debentures. Not only that, they also have to take decisions relating to approval for creation of charges on the assets of company. The tenth step is issue of debenture certificate. As discussed earlier, debenture certificate acts as an evidence that the company has taken loan from the person whose name is specified therein. The SEBI specifies that a company needs to complete the procedure relating to allotment of debentures within a period of 60 days from receiving of application money. Further, it must issue debenture certificate to the debenture holders within a period of 6 months from allotment of debentures. Let us now move towards the 11th and the last step involved in procedure relating to issue of debentures, which is making or posting entries in the register of debenture holders. Lastly, the company secretary is required to make necessary entries in register of debenture holders, and that too within a period of 7 days after approval of board for allotment. However, if the company issues debentures in demat form, then in such a case there is no need to maintain register of debenture holders. So with this, we have completed the 11 steps involved in procedure relating to issue of debentures. Let us now move towards next question, that is question number 5, which is who are debenture trustees? We have already understood about debenture trustees, but this question could be separately asked for 2 marks or 4 marks. So let us understand how to write this answer. Firstly, a company which issues prospectus or it invites more than 500 persons to buy or subscribe its debentures, then in such a case it has to appoint either one or more than one debenture trustees. Secondly, debenture trustees are those institutions which protect the interests of debenture holders. As discussed earlier, the company creates a charge on its assets to safeguard, to protect the debenture holders, and these trustees thus become the custodian of such assets. Further, debenture trustees are appointed either before the prospectus or offer letter is issued or within a period of 60 days after the allotment of debentures. Next, The trustees must give a written consent, that is, a written permission that they are ready to act as debenture trustees. Lastly, the prospectus must clearly mention the names of debenture trustees. Let us now move towards question number 6, that is, what is debenture trust deed? This is the last question in this chapter. Firstly, debenture trust deed is a legal instrument, that is, it is a legal document which consists of the terms and conditions of agreement between the company and debenture trustees. The deed also explains, or that is, it defines the rights of debenture holders. Not only that, it also speaks about the powers and the duties of debenture trustees. Further, the deed must be executed, that is, it must be prepared by the company within a period of 3 months of closure of the issue. The deed further can be inspected by the members, that is the shareholders, as well as the debenture holders. Both members and debenture holders have a right to inspect the debenture trust deed. Further, they can also get a copy of it by paying certain fees. So with this, we have completed our fourth chapter, that is issue of debentures. It is a small chapter containing of only 6 questions. Thank you, dear children, for your patience listening.